Hello. Hello, and welcome to another Osher Lifelong Learning Institute talk today with Dean Erwin Chemerinsky of the Berkeley School of Law. As you know, what we will do is give Dean Chemerinsky about 45 minutes to talk about the Supreme Court and what's going on there now, and then he'll take about 15 minutes of questions. If you do have a question, please type it into the chat column, and he'll go to the chat column at the end of his talk. He is someone who needs no introduction, and Erwin, I really am not going to introduce you. I'm simply going to say you are America's leading and most brilliant constitutional scholar, most quoted of all, author of many books. I say nothing more. The screen is yours.
Thank you so much. It's always an enormous pleasure to do programs for OLLI. Thank you for inviting me. It is another momentous year in the United States Supreme Court. I want to begin by focusing on 9 days at the end of June of 2022, and then want to talk about what we're likely to see from the Supreme Court during June of 2023. But I do think in order to understand where we are now, those 9 days from June 21st to June 30th of 2022 are so important, and momentous is the right word. Let me start with Tuesday, June 21st of last year. The Supreme Court decided a case, Carson versus Macon. It came out of the state of Maine. There are parts of Maine that are too rural to support local public school systems. In those areas, the state provides parents money to send their children to private school. But 5,000 children a year are affected by this. The only requirement imposed by the state is that it has to be used in a secular private school. The funds can't be used at a religious school. Two families that wanted to use the money to send their children to religious school brought a challenge. The lower courts ruled against them. The lower court said that Maine has a crucial interest in providing a free secular education for all of its children. They said that Maine has an interest in not taxing some people to support the religion of others. The Supreme Court, in a 6-3 decision, split along ideological lines, ruled against the state of Maine. Chief Justice Roberts wrote for the court and said, whenever the government provides aid for secular private education, it is constitutionally required to provide that aid for religious education. It violates free exercise of religion, he said, to deny the assistance. This is a dramatic change in the law. For decades, the issue was, when may the government give assistance to religious schools without it violating the Establishment Clause of the First Amendment? Now the issue is, when must the government give aid to religious schools where the failure to do so violates free exercise of religion? Just to give you a practical example, California has a law that says that charter schools can exist. These are schools paid for by the government, but are privately run. But California law says charter schools must be secular. There's now a lawsuit arguing that that violates the Constitution. And I just saw in today's newspaper that in Oklahoma, they are creating religious charter schools run by the Catholic Archdiocese. 2 days later, on Thursday, June 23rd, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin. It involved a New York law adopted in 1907 that prohibiting guns in public unless someone had a permit. To get a permit, someone needed to show a safety need for having a gun in public. The Supreme Court, in a 6-3 decision, split along ideological lines, declared this unconstitutional. Justice Clarence Thomas wrote for the court. The case is significant because the first time the Supreme Court has ever said there's a right to have guns, including concealed weapons, in public. But the court went much further and said that the only regulation of guns will be allowed is that which was permitted in 1791, when the Second Amendment was adopted, and maybe 1868, when the 14th Amendment was ratified. To show you the importance of this, a few months ago, Federal Court of Appeals in Texas ruled that a federal law is unconstitutional that says that people who have a restraining order in a domestic violence case can't have a firearm. The Fifth Circuit Court of Appeals said such laws didn't exist in 1791 or 1868, so they're unconstitutional today. In that case, on its way to the Supreme Court. The next day, Friday, June 24th, the Supreme Court decided Dobbs versus Jackson Women's Health Organization. As you know, the Supreme Court overruled Roe versus Wade and said the issue of abortion is left to the political process, that states can prohibit all or virtually all abortions, as many states have done. 3 days later, on Monday, June 27th, the Supreme Court decided Kennedy versus Bremerton School District. Joseph Kennedy was a high school football coach in Bremerton in Washington State. He made it a practice of going onto the field after games, going onto the 50-yard line and kneeling and praying. Sometimes he was joined by players from his team, sometimes players from both teams. A parent complained. The father said that his son and the family were atheists, and the son felt that he would get less playing time if he didn't join in the prayers. The school asked the coach to stop going onto the field and praying after games. The coach briefly complied. He then began the practice of going on the field after games and delivering what he called a Christian inspirational message, a prayer, again being joined by players of his team and both teams. The school put him on administrative leave and gave him a poor performance evaluation. Coach Kennedy sued and said it violated his free exercise of religion and his free speech. The Supreme Court, in a 6-3 decision, split along ideological lines, ruled in favor of Coach Kennedy. Justice Gorsuch wrote for the court and said it violated Coach Kennedy's free exercise of religion and freedom of speech to keep him going on the field after games and praying. Think again about what a dramatic change in the law this is. For over 60 years, the Supreme Court had said that prayer in public schools, even voluntary prayer, violates the Establishment Clause. Now the Supreme Court is saying restricting prayer violates free exercise and free speech. By definition, any limit on prayer in schools or any place else restricts the free exercise of religion and the free speech of those who want to pray. The Supreme Court has now opened the door to prayer in schools in a way that it hadn't been in decades. Finally, 3 days later, on Thursday, June 30th, the Supreme Court decided West Virginia versus Environmental Protection Agency. It involved the authority of the Environmental Protection Agency to regulate greenhouse gas emissions from coal-fired power plants. Coal-fired power plants are a major source of the pollution that's leading to climate change. The lower courts had upheld the authority of the EPA, but the Supreme Court, again in a 6-3 decision, here the majority opinion written by Chief Justice Roberts, said that the EPA lacked the authority to do this. He said, whether the EPA has the power is a major question of economic or political significance. He says Congress wasn't sufficiently specific in saying the EPA could do this. But as Justice Kagan pointed out in her dissent, the Clean Air Act says that the EPA can regulate pollution from stationary sources. Greenhouse gas emissions from coal-fired plants obviously fit within that. More important, what's a major question of economic or political significance? What's sufficient congressional guidance to meet this requirement? The court doesn't say, and has opened the door to challenges to countless administrative regulations. Well, it's in this context, with this in mind, that I want to talk about this term of the Supreme Court and what to expect between now and June 30th, 2023. Sometimes after a blockbuster term like last year, the court follows it with a more low-profile, sleepier term. Not now. The court has got a number of cases before it that have enormous implications for the law, for people's lives. Let me go through some of those areas, and I'll do it alphabetical by topic. So I begin first talking about this year in the court with affirmative action. 2 cases were argued in the Supreme Court on October 31st, 2022. Students for Fair Admission versus University of North Carolina and Students for Fair Admission versus Harvard College. In 1978, in Regents of the University of California versus Bakke, the Supreme Court said, especially in an opinion by Justice Lewis Powell, that college universities have a compelling interest in having a diverse student body. College universities may use race as one factor among many in their admissions decisions to benefit minorities and enhance diversity. Bakke involved the University of California Davis Medical School. It set aside 16 slots in an entering class for students of color. Alan Bakke, a white man, was not admitted and sued. The Supreme Court said the set aside of 16 slots was impermissible, but the University of California Davis could look at race as one of many factors in admissions to enhance diversity and benefit minorities. The Supreme Court reaffirmed that 25 years later, and here the case was Grutter versus Bollinger. This is a case involving the University of Michigan Law School. It followed what the Supreme Court said. It used race as one of many factors in admission decisions. And Barbara Grutter, a white woman who was denied admission, sued. The Supreme Court ruled in favor of the University of Michigan Law School. Justice Sandy O'Connor wrote for the court. She stressed the importance of diversity in the classroom and on campuses. And the Supreme Court reaffirmed this again in June of 2016 in University of Texas, Austin, Fisher versus University of Texas at Austin. Abigail Fisher, a white woman, was denied admission to the University of Texas and sued, and she lost in the Supreme Court, with the Supreme Court reaffirming the earlier holdings. So why is the issue of affirmative action back before the Supreme Court just 7 years later? There's an easy explanation. The composition of the Supreme Court has dramatically changed. All three dissenting justices from Fisher in 2016 remain on the court. Chief Justice Roberts, Justice Alito, and Justice Thomas. They've been joined by three conservative justices, Justices Gorsuch, Kavanaugh, and Barrett. I don't think there's anyone who listened to the oral arguments on October 31st who has doubt about what the Supreme Court is going to do. I think the Supreme Court is going to say that affirmative action violates the Constitution and violates federal law. Why are there two cases before the Supreme Court? The Equal Protection Clause of the 14th Amendment, like all constitutional protections, applies just to government institutions. Private entities don't have to comply with the Constitution. But Title VI of the 1964 Civil Rights Act says recipients of federal funds cannot discriminate on the basis of race. And the Supreme Court has said that the standards under Title VI are the same as under the Constitution. So students to fair admission for University of North Carolina involves the Equal Protection Clause. Students for fair admission versus Harvard College involves a private university in Title VI. What will it mean to eliminate affirmative action in all colleges and universities? We can see the implications by focusing on California. As I'm sure you remember, in 1996, California voters passed an initiative, Proposition 209, that said that the state and all of its subdivisions cannot discriminate or give preference on the basis of race or sex in education, employment, or contracting. In other words, affirmative action was outlawed in public education here in California back in 1996. There was an immediate devastating effect on diversity at the University of California. At UC Berkeley and UCLA, the number of African-American Latinx freshmen fell by 50% after Prop 209. It took UCLA 19 years until 2015 to get back to its pre-1996 levels of diversity. Now, the University of California and schools in places like Michigan and Washington, where affirmative action is also prohibited, have found ways to achieve diversity, notwithstanding the ability to engage in affirmative action. But it took concerted effort, it took trial and error, it took many years. My guess is we're going to see an immediate drop in diversity in elite college universities. 60% of all selective college universities engage in affirmative action. I worry that some schools will simply give up. Others will flout. I also think here there's a real role for California and Michigan and Washington schools that have done without affirmative action to be leaders for schools across the country. I'm very involved in the Association of American Law Schools, and we're doing a program on July 10th that I'm sharing on how law schools will be able to achieve diversity without being able to engage in affirmative action. But make no mistake, these are cases that are going to have real impact, at least in the short term, on diversity in college and universities. A second area that I want to talk about this morning concerns elections. And there are two cases to be on the lookout for in the next few weeks. The first of these is Merrill versus Milligan. It involves the Voting Rights Act of 1965. I regard the Voting Rights Act of 1965 as one of the most important laws adopted in my lifetime. There was a long, tragic history of disenfranchising voters of color, especially in southern states. In 1964, only 43% of eligible Black voters were registered to vote in southern states. In 1964, only 24% of eligible Black voters were registered to vote in Mississippi. The Voting Rights Act of 1965 did many things. One of the most important was found in Section 5 of the law. It said that jurisdictions with a history of race discrimination in voting would have to get pre-approval. It was called pre-clearance before significant change their election systems. This requirement was tremendously successful. There are hundreds of instances where pre-clearance was denied, likely thousands where it wasn't even sought because it would likely be denied. But in June 2013, in Shelby County versus Holder, the Supreme Court declared these provisions requiring pre-clearance to be unconstitutional. No jurisdictions need to get pre-clearance any longer. Immediately, states like North Carolina and Texas put into effect the very laws where pre-clearance had been denied. The Voting Rights Act also did something else. In Section 2, it said, state and local governments could not have election systems or practices that discriminate against voters of color. In 1982, Congress amended this to be clear that proving a discriminatory effect against voters of color was sufficient for a violation. 2 years ago, in Brnovich versus Democratic National Committee, the Supreme Court made it harder to prove that election practices violate Section 2 of the Voting Rights Act. Merrill versus Milligan, I think, is going to make it much harder to prove that districting that discriminates on the basis of race violates Section 2 of the Voting Rights Act. Let me tell you about the facts of the case. Comes out of Alabama. The population of Alabama is 27% Black individuals. There are 7 congressional districts in Alabama. After the 2020 census, the Alabama legislature engaged in redistricting, and it packed as many Black voters as possible in one district, and then spread the other Black voters around the other 6 districts. So it was very likely that only one Black individual will be elected to Congress from the state of Alabama. A 3-judge federal court found that this violated the Voting Rights Act. 2 of those judges were conservatives appointed by Donald Trump to the bench. They said that it's clear that there was a discriminatory effect against Black voters that violated the Voting Rights Act. The Supreme Court stopped that court's order from going into effect. The discriminatory maps were used in the primary and general elections in 2022. And the Supreme Court granted review. The case was argued the second day of the term on October 4th. I very much worry that the Supreme Court is going to further gut the Voting Rights Act and make it harder to prove that how election districts are drawn violates the Voting Rights Act for discriminating against minority voters. The other case with regard to elections is the case that I'm most worried about this year on the Supreme Court's docket. And I keep waiting for them and hoping that they will just dismiss it. The case is Moore versus Harper It was argued on Wednesday, December the 7th. It involves the so-called independent state legislature theory. Case comes out of North Carolina. North Carolina is basically a purple state. It went for Obama in 2008. It went for Trump in the next two presidential, for Romney in 2012, and then Trump in the next two presidential elections, but always by a razor-thin margin. In 2020, Trump beat Biden in North Carolina by 1.35%. The North Carolina legislature is controlled by Republicans. After the 2020 census, they drew an election map, Congress, where Republicans were likely to win 10 of 14 seats. A challenge to this was brought into the North Carolina courts under the North Carolina state constitution. The North Carolina Supreme Court found that the district violated the state constitution. It created a nonpartisan commission to draw new maps. They were used in the November 2020 election, and Democrats won 7 seats, Republicans won 7 seats, and that fits with Democrats and Republicans statewide get almost exactly the same number of votes for seats for Congress. But the Republican leaders in the North Carolina legislature went to the Supreme Court. And they said the North Carolina Supreme Court had no jurisdiction to order a remedy. They said that only the legislature of the state gets a word on this, and its word is final and conclusive. The legislative leaders pointed to language in Article 1, Section 4 of the Constitution that says the legislature of each state shall determine the time, place, and manner of elections to Congress. And their argument is legislature means legislature. Courts can't get involved. Of course, everything the legislature does has to be constitutional. It's always been the judicial role to make sure. But now what the Republican legislative leaders are arguing is that the court can't enforce the law. This would have dramatic implications. It would mean that there can't be independent districting commissions like we have in California for congressional seats. It would mean that there'd be no check on partisan gerrymandering, no matter how egregious or extreme. But the implications go beyond that. There's another provision of the Constitution in Article 2, Section 1, that says the legislatures in each state shall allocate the electors in that state in the Electoral College. The argument is then that the legislature gets to decide where the electors go in the Electoral College, notwithstanding that every state has a law that says the electors should go to the winner of the popular vote. Well, imagine the following. Imagine the 2024 presidential election is as close as the 2020 presidential election. Imagine there are a few states that have Republican state legislatures, but the Democrat carries the popular vote for president. Make them Wisconsin, Georgia, Arizona. And imagine that the legislature decides to give that state's electors to the Republican candidate for president, notwithstanding the Democrat winning the popular vote and a state law that says the winner of the popular vote gets the electoral vote. And imagine that decides the 2024 presidential election. I don't think it's hyperbole to say I don't think our democracy in our country could survive that happening. That's what Donald Trump tried to do in 2020 unsuccessfully. But if the Supreme Court embraces the independent state legislature theory in Moore versus Harper, it'll be quite different in 2024. Interestingly, the North Carolina Supreme Court has reversed itself in this case. When Moore versus Harper was first decided by the North Carolina Supreme Court, there were 4 Democratic justices and 3 Republican justices. After the November 2022 elections, there are now 5 Republicans and 2 Democrats on the North Carolina Supreme Court, and they reversed their earlier ruling. So the question is, does that divest the United States Supreme Court from jurisdiction? Does the case just have to be dismissed? I would think so, but it hasn't happened yet, which may mean the court's going to still decide it, or it may mean that they're just working on various opinions. But it's certainly a case. Pay careful attention to it. The next area that I want to talk about concerns the First Amendment and freedom of speech. And there are two very important cases that will come down between now and the end of June. The first is 303 Creative versus Olennis. The issue is, how is it to be determined what's a true threat that's unprotected by the First Amendment? The Supreme Court has said for decades, I'm sorry, the 303, that's kind of what's going on. 303 Creative versus Olennis involves a question of when can someone violate an anti-discrimination law on account of religious beliefs or freedom of speech. Colorado has a law that prohibits business establishments from discriminating on the basis of race, sex, religion, sexual orientation. Lori Smith runs a business in Colorado designing websites. She wants to expand her business to design websites for weddings, but she doesn't want to design websites for same-sex weddings. So she brought a lawsuit in federal court in Denver, arguing that she should be able to violate the Colorado law because to apply it to her, to require that she design websites for same-sex weddings, violates her free exercise of religion and her freedom of speech. Lori Smith lost in the lower courts in Colorado. They ruled that the state has a compelling interest in stopping discrimination based on sexual orientation, and that compelling interest justifies prohibiting discrimination on grounds of sexual orientation. But Lori Smith took the case to the Supreme Court. The case was argued on Monday, December 5th. I think it's likely that the Supreme Court's going to rule in favor of Lori Smith and say that it violates her freedom of speech to say that she has to design websites for same-sex weddings. Here's why this matters so much. There's always a tension between liberty and equality. Any law that prohibits discrimination limits the freedom to discriminate. But for over a half century, the Supreme Court, and I would say overall our society, have made the judgment that stopping discrimination is more important than protecting freedom to discriminate. I think the Supreme Court is going to say here that freedom to discriminate outweighs the state's interest in prohibiting discrimination. Where is the stopping point going to be? Imagine a landlord who says it violates my religious beliefs to have to rent property to an interracial couple. Or imagine an employer says it violates my religious beliefs to have men and women in the same workplace, so I'm not going to employ women. Once the Supreme Court says there's a First Amendment right to discriminate in violation of anti-discrimination laws, where is the cabining principle? Where is the line to be drawn? The other case is Counterman versus Colorado, and that's the issue that I mentioned a moment ago of how is it to be determined what's a, quote, true threat unprotected by the First Amendment. The Supreme Court has said for over half a century that, quote, true threats are a type of speech that's not protected by the First Amendment. There was a case called the United States versus Watts in 1969. It involved a federal law still on the books that makes it a federal crime to threaten the president of the United States. And the Supreme Court said the law is constitutional, but the court said it's important to draw a distinction between, quote, a true threat as opposed to, quote, mere hyperbole. Well, how is a true threat to be determined? The lower courts are split almost evenly on this. Some say the question is, would a reasonable person feel threatened by the speech under the circumstances? If so, that's a true threat. These courts have said there's no First Amendment right to use speech to cause another person to reasonably fear and danger for his or her safety. But other courts have said it should be subjective. There should have to be a requirement of proving that it was the intent of the speaker to threaten. Here's the facts of Counterman versus Colorado. Billy Ray Counterman lived in Colorado. He became obsessed with a musician. She's identified in the case as just CW. He sent her over 1 million messages over social media. She never answered. To read them, there's the sense that he thought he was having a conversation with her, but she never participated. His messages became increasingly aggressive and abusive. She went to the police. Counterman was prosecuted and convicted under a Colorado statute that makes it a crime to engage in such harassment and true threats. He was sentenced to 4.5 years in prison after his conviction. The Colorado courts upheld his conviction. The Colorado courts said that under their standard, a reasonable person would feel threatened by these messages, and therefore it's not speech protected by the First Amendment. The matter is before the Supreme Court. The case was argued on April 19th. My sense is that the Supreme Court's likely to reverse and rule in favor of Billy Ray Counterman. I think the court's going to make it much harder to prove that speech constitutes a true threat. And I worry about that. I worry about it in terms of enforcing harassment laws. I worry about it in terms of protecting people. But I think that that's what's likely to happen. And again, we'll see in the next few weeks. The next area that I want to talk about concerns the Indian Child Welfare Act. There's a case called Hallen versus Burkine that was argued on November 9th. There's a long, tragic history in this country of taking Native American children away from their families and putting them for adoption, or at least in foster care, with white families. The Indian Child Welfare Act was meant to counter that. It says that when a Native American child is being placed in foster care or up for adoption, a presumption should be given in favor of Native American foster or adoptive parents. The question is that unconstitutional? There are a number of specific issues before the court. One is whether Congress had the authority to enact the statute. There's a provision in Article 1, Section 8 of the Constitution that says that Congress can regulate commerce with foreign nations, with Indian tribes, and among the states. Does that power to regulate commerce with Native American tribes give Congress the authority to adopt the Indian Child Welfare Act? Also, there's a law that says that Congress can't commandeer the states. Congress can't force the states to adopt laws or regulations. Is this impermissibly commandeering the states and telling them what they have to do? The issue that got the most attention, though, at the oral argument was whether or not this is an impermissible racial preference. Key underlying question here is, should be a member of a Native American tribe regarded as a racial status or as a political affiliation? If it's regarded as a racial status, then it's likely the Supreme Court is going to declare this unconstitutional, just like I think it's going to declare unconstitutional in the affirmative action cases, college, university engaging in that practice. If being a Native American is seen as a race and it's a racial preference, this is a court that's very hostile to racial preferences. On the other hand, there's a strong argument that says being a member of a Native American tribe is really a political affiliation. Native American tribes are separate sovereigns. And as separate sovereigns, isn't this about political affiliation? If it's about political affiliation, I think the court's going to uphold this. I think there are 4 justices to say that it's a political affiliation to uphold the Indian Child Welfare Act. Here it's Justices Sotomayor, Kagan, Gorsuch, and Jackson. But the question is, will they get a 5th vote? I fear often in talking about these cases, it sounds abstract. But let me give you a concrete example of why this matters. The University of California has adopted a plan of giving free tuition to Native Americans who are coming to the University of California. We have our own program where we give just tuition scholarships to Native Americans who are coming to the law school. It's a very successful program. We have 11 Native Americans who are coming to Berkeley Law for the class that will enroll in August of 2023. If being Native American is a political status, our and the University of California scholarship programs are constitutional. But if being Native American is a racial classification, then I think Supreme Court says that our program will be unconstitutional. So it's a case that will have huge practical significance in terms of people's lives. The final area I want to talk about before taking questions concerns strikes in unions. There's a case that was decided last Thursday by the Supreme Court on June 1st, Glacier Northwest versus Teamsters. Here's what's involved. Glacier Northwest produces cement. It sent its truck drivers out with cement trucks, with the cement mixers going, and the drivers then went on strike. They brought the trucks back to the place with the motors going, but the cement for that day got ruined. And Glacier Northwest sues the union, saying you should give us money damages to compensate us for the lost cement from that day. The trucks weren't damaged, it's just that the cement was not usable. Well, all strikes impose economic costs on the employer. That's what gives striking workers leverage. I mean, think of the strike going on now in Hollywood by the screenwriters. The strike is undoubtedly costing the studios, the networks, a tremendous amount of money. But that's what gives the writers leverage. There have been many cases in the past involving workers who engaged in strikes that caused the loss of perishables. So there have been cases involving striking workers with regard to eggs and milk and butter. And could the employers sue and recover? And the courts had consistently said no, that the loss of the perishables is incidental to the right to strike. The National Labor Relations Act, adopted in the 1930s, protects the right of unions to engage in strikes, to engage in collective activity for mutual aid and protection. Well, here, the Washington State Supreme Court ruled against Glacier Northwest and in favor of the union. The Washington State Supreme Court said that any cost that Glacier Northwest absorbed was incidental to the strike, and it was like the loss of perishables that I mentioned, the loss of butter, milk, eggs, when those kinds of workers go on strike. Besides that, there's a long-standing doctrine, going back to 1959, that the National Labor Relations Board should in the first instance decide if a strike is protected by federal law. And there is a proceeding pending with regard to the Glacier Northwest strike before the National Labor Relations Board. But the Supreme Court, in an 8-1 decision, reversed the Washington State Supreme Court and ruled against the union. Justice Amy Coney Barrett wrote the opinion for the court. Justice Ketanji Brown Jackson was the only dissenter. One of the puzzles for me is why didn't the other two liberal justices, Sonia Sotomayor and Elena Kagan, join with Justice Jackson in dissent? Here, the Supreme Court said that it was for the court to decide, not for the National Labor Relations Board to decide, whether there's a strike that was protected by federal law. And here the Supreme Court said that the union could be held liable. The court said the union could be held liable because its conduct was imminent, foreseeable, and aggravated. And when a union engages in conduct that's imminent, foreseeable, and aggravated, its members, the union, can be held liable for damages. But here's the crucial question for the future. What does imminent, foreseeable, and aggravated mean? To be clear, there's limits on what unions can do in imposing costs on employers. No union members have the right to burn down the building business. They can't throw bricks through the window and cause property damage. But on the other hand, there are always going to be economic consequences and costs to strikes. Go back to the Hollywood strike. In addition to the losses that the networks, the studios are suffering, What about all of the businesses that serve them? The catering companies and the like. They're all losing revenue. Can they now sue the union? Is it imminent, foreseeable, aggravated? It's certainly imminent and foreseeable, and I have no idea what aggravated means. Or take the strike that occurred at the University of California by the graduate students last November and December. Think of students who were graduating in January who didn't get the grades they needed for employment. Could they sue the union for money damages to recover for the harms that they suffered from the strike? To me, what's most troubling about what the Supreme Court did here is it usurped the authority of the agency that Congress created to make these determinations, the National Labor Relations Board, and it opened the door to suits for damages against unions for the costs that rise that are incidental to the strike. I don't know what it means to be imminent, foreseeable, and aggravated. I don't think a union is likely to be able to know what's imminent, foreseeable, and aggravated. And I worry that this will discourage and deter strikes. Strikes are one of the relatively few tools that workers have to be able to equalize bargaining power, to be able to gain concessions from employers. Now, it's true that the union here didn't give advance notice to Glacier Northwest, but federal law only has one instance where unions have to give advance notice to employers, and that's for healthcare workers, which obviously wasn't involved here. So the Supreme Court, I think, has given a major victory to employers and a serious blow to unions in the right to strike by so opening the door to economic liabilities for the union when there is a strike. So these are some of the cases. All of the ones that I just described to you are likely to come down between now and June 30th. So just over the next few weeks. And I expect, like last year, we'll get a flurry of decisions in the last 10 days. So with that, I've talked almost my 45 minutes, and I will look to do the questions. And I'll just read them from the chat.
If I might jump in with one broad
Please.
question.
Anything.
I don't doubt, as happens each time you speak with us, that many are listening to this and saying, what can I do about this? What is to be done? Would you address what you think are the most practical ways to deal with a court like this?
Sure. First, to be sure and vote and get others to vote. The reason we have the court that we do now is because people didn't go out and vote in 2016. Had Hillary Clinton won in 2016 rather than Donald Trump, and she picked those three justices, the court would be very different. According to CNN exit polls in 2016, the number one reason that Republicans gave for voting for Donald Trump, or voters gave for voting for Donald Trump, was the Supreme Court. For Hillary Clinton, the number 4 reason they gave for voting for her was the Supreme Court. We don't know when the next vacancy is going to be, but if you have a view with regard to what you want the court to be, you need to vote and to get other people out who are like-minded to vote. Elections really matter. Second, I think it's really important to get involved in the organizations that handle the issues that you care about. If it's about reproductive justice, there are terrific organizations like Planned Parenthood or like the ACLU who are involved fighting those issues. If it's about religion, it's organizations like Separation of Church, the Americans United for Separation of Church and State, or the Freedom from Religion Foundation. If it's about voting, it's organizations like the NAACP Legal Defense Fund. Because all of us are more effective working with others, and these are organizations that are doing it. Third, I think it's important to be looking much more to state courts and state constitutions to protect rights when possible, to the extent we can't do it through the Supreme Court and through federal constitutional litigation. And fourth, I think there are places we're going to need to look to the political process to protect rights. Abortion is an example of that. I mean, there have been some surprising victories, both in state courts and in state political processes with regard to abortion rights. And so I think we need to look to those areas. We can't give up, but it's going to be a court that's quite conservative for some time to come.
Second question, and then we'll go to the chat column. Could you speculate for me? I don't know how to grasp what these justices want the society to look like for their children, for their grandchildren. It seems they want a society where everyone carries guns and your only protection is to have your own gun or pray. Um, what what do you see as the world they want us all to live in?
Think of the current Republican conservative political ideology. And if you would ask yourself, what is animating conservatives now? I think that's how to understand the current Supreme Court. And there's certainly some among us today who would be able to say, this is what I believe, and I think the court's absolutely right. It's very much against abortion rights. That's been a key part of the Republican platform since Ronald Reagan ran in 1980. Is very much against separation of church and state and wanting to aggressively protect religion. It favors race neutrality and ending affirmative action. I think it has a very conservative agenda with regard to gay, lesbian, transgender rights. I don't think anyone, liberal or conservative, would disagree with what I've just characterized as core aspects of the conservative political ideology. We now have a court that's going to advance that political ideology. They were put there to do that. They are doing that, and they're going to do it. And so I think you just look in terms of national politics of what is central to political conservatives. That's this court.
Good. To the chat column we go.
Okay. Your thoughts on the reach of the recent Supreme Court ruling on worker unity liability when striking. And that's the case I was talking about at the end, the Glacier Northwest versus Teamsters. I did an opinion piece that was in Friday's Los Angeles Times on June 2nd with Catherine Fisk, who teaches labor law here at Berkeley. And the point we tried to make was just the one that I made to you, that I think the Supreme Court has opened the door to suing unions for damages for the incidental costs of their strike. All strikes have incidental economic costs. The question is, where is the court going to draw the line? The test they articulated is what I said to you, and I'm quoting, imminent, foreseeable, and aggravated. But what does that mean? How can California protect its laws and regulations to be bulletproof against discriminatory Supreme Court decisions? In other words, can we structure any laws to say we don't care what else applies elsewhere, but it doesn't apply here? It's a really important question, and you have to answer and draw a distinction where the Supreme Court has said the Constitution applies and limits what the government can do, as opposed to where the Supreme Court says the Constitution doesn't apply and the political process gets to decide. To illustrate that distinction, let me contrast the two cases from June 23rd and June 24th about the Second Amendment and about abortion. In the Second Amendment case, the Supreme Court said the Second Amendment protects the right of people to have guns in public, including concealed weapons. That then limits what states can do, and state regulations of guns have to comply with the court's interpretation of the Second Amendment. If I'm right that the Supreme Court's going to say that college, university can't engage in affirmative action, the court's going to say the Constitution applies and limits what the government, what educational institutions can do. But where the court says the Constitution doesn't apply, then that's left to the political process. So the court has said the Constitution doesn't apply with regard to abortion. The Constitution doesn't protect abortion rights. That's left to the political process. Where the court says there's constitutional limits, there's limits to what the state can do because it has to operate within those constitutional limits. Where the court says the matter is left to the political process, then that's where the state can act. And that, for example, is how California adopted constitutional amendment in November 2022 to provide more protection for abortion rights. Can you have a list of the cases that I talked about? Sure, I could provide
We can do that. We can do that, Dean Chemerinsky. No problem.
Okay, but I can certainly do that as well. Seems to me that in Glacier Northwest, the court gave employers 2 bites at the apple, the NLRB and the state courts. There always was the NLRB. And under the Garmin decision from 1959, it was always thought that it was the National Labor Relations Board to decide if a strike was arguably protected by the National Labor Relations Act. And Congress created the National Labor Relations Board, so there would be an expert body making this determination. Now, what the Supreme Court has said is that even though there was a proceeding pending before the NLRB, the state courts should be able to award money damages when a strike has imminent, foreseeable, aggravated effects. So it does create an alternative forum to the NLRB. And Justice Jackson, in her dissent last Thursday on June 1st, really emphasized that. Can you please comment on the action that will be taken to address the conflicts presented by Clarence Thomas's behavior? I think that it's essential that there be a code of ethics for Supreme Court justices. There is a code of ethics for all other judges in the country, federal and state. The only judges who don't have a code of ethics are the most important ones, the Supreme Court justices. My hope is that the justices would on their own have adopted a code of ethics by now, but they seem unable or unwilling to do that. So I think it's essential that Congress pass a law that either imposes a code of ethics or requires the Supreme Court to devise a code of ethics. I believe that Congress has the authority to do this. In fact, I've just written an op-ed that's going to come out in the New York Times that argues that Congress has this authority. There are already federal statutes that regulate what Supreme Court justices can do. There's no reason Congress can't adopt more extensive regulations. And separation of powers doesn't mean that one branch of government is autonomous of the others. Congress sets the budget for the Supreme Court. Congress sets the size of the Supreme Court. So I think Congress should set a code of ethics for the Supreme Court. The Supreme Court doesn't do it itself. I think there has to be an enforcement mechanism. My colleague, former Judge Jeremy Fogel, has proposed having a panel of retired Court of Appeal judges decide whether or not a Supreme Court justice is disqualified. Now it's left to the individual justice to decide whether to be recused, and I don't think any person should be a judge of himself or herself. In terms of Clarence Thomas, I think that the conflicts of interest here are quite egregious, but I'm not sure what can be done about them. The only remedy for a sitting justice is impeachment or removal, and I don't foresee a majority of the House and 2/3 of the Senate being willing to do that. I'd like to explore the question above atheists. As an atheist, can I legally discriminate against Christians? I think the Supreme Court, as I said, is likely to say that individuals based on their religious beliefs can discriminate, at least in the context of something like 303 Creative versus Lennis. I don't know that the Supreme Court would be willing to say that atheists can discriminate on account of their religious beliefs, because it's about free exercise of religion. And can you say that being an atheist is a religious belief? It almost sounds like an oxymoron to say that being an atheist is a religious belief. But I'm sure we will see this come up. I'll tell you what it also concerns me is all of the cases that the Supreme Court has decided have involved the Christian religion. Does Lori Smith, a Christian, have the right to discriminate against same-sex couples? Did Joseph Kennedy, a Christian, have the right to go onto the field and pray? Did the families in Maine who were Christian have the right to send their children to religious school at the government's expense? I would hope that the Supreme Court will apply the same rules when it's non-Christians, Muslims, Jews, Buddhists, and so on. But I don't know. And I think it's in that context, the question is, will they give atheists the same right to discriminate as they give to Christians, or give it to the religious individuals? And I don't think we know. One thing to keep in mind is the Supreme Court for over 40 years had said that there's not an exception for a general law on account of somebody's religious beliefs. The law that prohibits discrimination is a general law. You don't get an exception up till now for your religious beliefs. Once the court says you do get an exception to a law for your religious beliefs, then courts are going to face the really difficult task of defining what's a religion and how to determine what's a sincerely held religious belief. Next question. Jews do not believe abortion is objectionable if the fetus is quickened, viable. Would a challenge to abortion restrictions by a Jew based on religious freedom have legs? In fact, there's a strong argument that, at least for many Jews, it's not until birth that there's a human being that's protected. There are lawsuits pending now in Florida, Indiana, and Kentucky about this. And here's how it comes up. There are a number of states that prohibit all abortions, except if necessary, to save the life of the woman. There's no exception to protect the health of the woman. But there are Jews who say it's against my religion to not have an abortion because my religion says my life takes priority and health takes priority, and if it's endangering my health, I should have an abortion. I think that's the place where the issue will come up, where the law prohibits abortions to protect the health of the pregnant person, but the person's religion would say you should have an abortion in this circumstance because your health gets priority. And I think if the Supreme Court is true to its views with regard to religion, it should create an exception in those circumstances. But I want to be clear, this would not be a basis for declaring unconstitutional the state law that prohibits abortion. It'd be a basis for saying the law is unconstitutional as applied to these individuals whose religion would require an abortion. Any thoughts on Steve Vladeck's new book, The Shadow Docket? I just have read it. It's terrific. Steve Vladeck is a professor at the University of Texas Law School. And the Shadow Docket is the Supreme Court's emergency rulings. There have long been emergency rulings by the Supreme Court. It often comes up when somebody is facing execution in a capital case and they want an emergency stay from the Supreme Court. But what Professor Vladeck shows is that the Supreme Court has tremendously expanded its emergency rulings, often handing down rulings that are treated as a precedent, even though there was no briefing and argument in the case. So I highly recommend Professor Vladeck's book. Is there
I
an
think we
argument?
can stop there, Erwin.
Okay, there's one
last
more
25.
question, I think.
Oh,
I can do
okay.
the last question, and then I've gotten
Sure.
them all. Is there an argument that employers are recouping costs by withholding pay to striking employees? Well, that would be really interesting because employers don't have to pay striking workers. And would that then have to be set off against any damages that the employers recover? I'm sure that would be litigated. It's a great question. And now I think I've done all the questions.
Okay. There we go. And thank you so much. I wanted to take this last minute just to thank you on behalf of OLLI. I can't tell you how much we all appreciate your joining us to tell us about the Supreme Court. Thank you so much.
My great pleasure. Thank you for having me.
Okay. We will see you again, hopefully in the near future.
Thank you.